Welcome to This Explainer. Today, we're dissecting a rather fascinating Philippine Supreme Court case, GR No 241036. Now, we're going to transform what looks like a super complex legal battle into a clear, easy-to-follow journey. It's honestly a perfect example of how a messy, real-life family drama gets distilled into strict legal doctrine. So let's just jump right in. So our main question today feels like something straight out of a primetime soap opera. If your father marries again, can you legally cancel that second marriage after he dies just to protect your inheritance? I mean, it sounds like it should be a simple yes or no, right? But as you're going to see, the law is rarely ever that straightforward. Here's our roadmap for untangling all this. First, a messy family inheritance. Second, the battle of jurisdictions. Third, who can actually annul a marriage? Fourth, the children's legal recourse. And finally, the first wife's remedy. Section 1. A messy family inheritance. Okay, so to really understand this, we need to establish the facts surrounding the Aquas family, because these facts are literally what set this entire legal machine into motion. Let's trace how this all unfolded. Back in 1981, Rene marries his first wife, Lucilla. Fast forward a bit to 2005, and that marriage is judicially declared null and void. But here is the massive catch. The conjugal property was never actually partitioned, and the children's guaranteed inheritance, what's called their presumptive legitime, well, that was never delivered before he remarried. So in 2006, Rene goes ahead and marries his second wife, Cherry. Finally, in 2015, Rene passes away intestate, which just means he died without a will. And as you can probably guess, all of this left the estate in complete, utter legal limbo. With Rene gone, wife number 2, Cherry, files a petition to settle the estate in 2017. Naturally, this prompts wife number 1, Lucilla, and her 5 children to file a direct petition to nullify that second marriage. Their whole argument was that because the property split from the first marriage was never properly recorded, the second marriage has to be legally void. Section 2. The Battle of Jurisdictions. Now, when they filed this petition, it triggered an incredibly confusing courtroom shuffle over who actually had the authority to hear the case. Basically, the petitioners kept knocking on all the wrong doors. They originally filed in Branch 59, which is the designated family court. However, the family court transferred the case away, claiming that the heirs were making a collateral attack that just didn't belong there. So the case gets re-raffled over to Branch 60, a regular court. But guess what? The regular court outright dismissed it, stating that petitions for nullity of marriage fall exclusively under the jurisdiction of family courts. Talk about a total procedural nightmare, right? To untangle this, we really have to look at the definition of jurisdiction. The Supreme Court pointed out that since the heirs directly asked to nullify a marriage in their complaint, the family court, Branch 59, actually did have the correct jurisdiction over the subject matter. Branch 59 simply misunderstood the heirs' legal standing, and they mistakenly transferred the case instead of just dismissing it outright. So the regular court, Branch 60, was completely right to dismiss it when it landed on their desk. Section 3. Who can annul a marriage? And this brings us right to the core legal puzzle that the Supreme Court had to resolve. Under the rules covering the family code, if a marriage is void, who exactly has the legal right to file the petition to declare it so? Is it just the spouses? Can the children step in and do it? What about a former spouse? It's a really great question. Well, the Supreme Court rule on this is absolute. It leaves absolutely no room for doubt. It states that a petition for declaration of absolute nullity of void marriage may be filed solely by the husband or the wife. Solely. This rule governs direct actions for marriages covered by the family code. So the crucial takeaway here is that compulsory heirs, like the 5 children in our case, simply do not have the legal personality to directly cancel their father's second marriage. The rationale here is actually pretty interesting. It's because compulsory heirs only have inchoate or incomplete rights, meaning their actual right to inherit doesn't fully lock in until the parent passes away. And since the state's main concern is preserving the institution of marriage, it strictly limits the power to seek its dissolution directly to the spouses themselves, no one else. Section 4. The children's legal recourse. Now, you might be wondering, if they can't file for nullity, what happens to the children's inheritance? Are they just completely out of luck? Actually, not at all. The Supreme Court carefully splits the remedies here. They make sure both the children and the first wife have different, specific legal doors to knock on. The law absolutely doesn't leave them helpless. It just redirects them to the correct procedural paths. For the children, their statutory right to succeed their father means they must go to the settlement court. Remember wife number two's petition to settle the estates? That was already happening over in Branch 56. Under the rules, the specific court that first handles the settlement of an estate gets exclusive jurisdiction over the whole thing. So Branch 56 is literally the only place the children can go to protect their rights. And this is where the concept of a collateral attack comes into play. See, in the estate court, the children are legally allowed to launch a collateral attack against that second marriage. Now, they can't file a direct petition to annul it, we already established that, but they can argue that it's void during the estate settlement, purely to protect their share of the inheritance. It's a pretty subtle but absolutely massive legal distinction. Section 5. The first wife's remedy. Okay, but what about Lucilla, the first wife whose property from the first marriage was never properly partitioned? Where does she go to get this sorted out? Here's how her legal path builds. Step 1. Because her marriage was voided way back in 2005, Lucilla is no longer considered a spouse. Step 2. This means she is legally a stranger to Renee's estate, so she can't claim as an heir. Which naturally leads to Step 3. She has to sue the estate administrator directly. And this is exactly why she couldn't just join the children in the estate court. An intestate or estate court has limited jurisdiction. It cannot finalize ownership claims from outside parties who claim a title adverse to the deceased. It really only figures out what is actually in the estate and who the valid heirs are. Since Lucilla is claiming her own half of the unpartitioned conjugal property as an outside party, the estate court just can't help her. Therefore, the Supreme Court ruled her only remedy is to file a totally separate civil action against the estate's administrator, just to carve out her half of the property. As the decision clearly lays out, she has to go to a regular court to demand partition of that property. It's a completely separate process. Ultimately, the Supreme Court really cleaned up this procedural mess. They upheld the regular court's dismissal of the original nullity petition simply because the wrong people filed it. They officially directed the children over to the estate court to raise their collateral attack, and they directed Lucilla to file a separate civil action for partition. So you see, everyone gets a remedy, but they absolutely have to use the correct procedure to get there. Which leaves us with this final, crucial thought. Having a valid grievance is only half the battle. The other half is knowing exactly which courtroom door to knock on. This explainer perfectly highlights why procedure matters just as much as the substance of the law. I mean, you can be entirely right about your facts, but if you don't follow the proper legal roadmap, your case is going to go absolutely nowhere. So next time you hear about a complicated family dispute, remember, the venue is just as important as the claim. Thanks for joining me on this explainer, and keep asking the right questions.